Good afternoon. My name is Dan Attridge. I'm the new dean at the law school at Catholic University of America. I began on February 1st, so when I say new, I mean I'm really new. I wanted to thank our panelists who Professor Drinan will be introducing. We really appreciate them taking their time out of their busy schedules and joining with us in this evening's program. I also want to thank all of you in our Catholic University community, our alumni, our friends. Everyone is here with us this evening. We really appreciate it. For those of you who are unaware, this program tonight is really a continuation in some respects from a symposium that was held last Friday at the law school. It's also a part of our series of programs here at the Press Club in order to have the law school come downtown, if you will, in order to meet our friends and our audience in this particular location. I'll, at this point, just turn it over to Professor Drinan, who will serve as our moderator, and she'll also be introducing our panelists. Thank you very much.
Thank you, Dean Attridge. For the last 4 decades, a tough on crime stance has been a requirement for politicians on both sides of the aisle. As the title of tonight's panel suggests, tough on crime is yielding to the concept of smart on crime. Our criminal justice policies of the last 4 decades have generated 3 strikes laws, mandatory minimums, the prosecution of children as adults, and the huge expansion of criminal laws at the state and federal level. The result of these policies is that the U.S. now leads the world in its rate of incarceration, with more than 2 million behind bars. The American correction system is incredibly expensive, both in taxpayer dollars and in human capital. But hope for meaningful bipartisan criminal justice reform is on the horizon. This past fall, California voters repealed the state's 3 strikes law and almost voted to eliminate the death penalty. Death penalty repeal or reform is on the 2013 legislative agenda in Alabama, Colorado, Maryland, Kentucky, New Hampshire, Oregon, even Texas, largely because of bipartisan concerns about cost and fairness. The Right on Crime organization, founded by Newt Gingrich and other conservatives, signals that politicians on the right are interested in addressing overcriminalization and inmate reform. Criminal justice reform appears to be truly becoming a bipartisan issue, and each of our panelists is contributing to this emerging smart on crime dialogue. It is my pleasure and honor to introduce them to you tonight. Now, I should say I could spend the whole hour just introducing our panelists, and at the same time, they hardly require any introduction at all. But I will say a few words about each of them, and I will introduce them in the order in which they will speak. So let me begin with Governor Robert L. Ehrlich Jr. Governor Ehrlich served as the 60th governor of Maryland from 2003 to 2007, and in the U.S. House of Representatives. He's currently senior counsel at King & Spalding here in D.C. Ehrlich grew up near Baltimore in Arbutus, Maryland. He attended Princeton University and Wake Forest University School of Law. Among other achievements, he's credited with strongly supporting education, achieving environmental reform, and establishing the first cabinet-level disabilities office of any state in the nation. As governor, he earned national recognition for his approach to clemency and his robust use of that executive power. Let me now introduce General Edwin Meese III. General Meese served as the 75th Attorney General of the United States from February 1985 to August 1988. From 1981 to 1985, Mr. Meese held the position of Counselor to the President, the senior position on the White House staff, where he functioned as the President's Chief Policy Advisor. Prior to that, General Meese served as Governor Reagan's executive assistant and chief of staff in California and as his legal affairs secretary. In the latter position, he was responsible for advising Governor Reagan on matters of executive clemency. General Meese currently holds the Ronald Reagan Chair in Public Policy at the Heritage Foundation. To his right and my left is Congressman Robert C. Bobby Scott. Congressman Scott is currently serving his 11th term in Congress, representing Virginia's 3rd District. The congressman serves on the Committee on the Judiciary and is a member of the Subcommittee on the Constitution and Civil Justice. Congressman Scott has an impressive legislative record in the criminal justice arena. In 2010, he successfully led efforts in the House to pass the Fair Sentencing Act, which reduced the crack and powder cocaine sentencing disparity. And he's currently pursuing juvenile justice reform and crime prevention through the Youth Promise Act. And last but not least, let me introduce Ms. Margaret Colgate Love. Ms. Love received her law degree from Yale, and she has a master's degree in medieval history from the University of Pennsylvania. She practices law here in DC, specializing in executive clemency, restoration of rights, sentencing and corrections policy, and legal and government ethics. Her scholarship focuses on pardon policy and practice, as well as collateral consequences of criminal convictions. Ms. Love served as the U.S. pardon attorney from 1990 to 1997, and she currently directs the ABA's national inventory of the collateral consequences of conviction. So before I turn the panel over, or the podium over rather, to Governor Ehrlich, let me just remind everyone of our format for tonight. We will hear from each panelist regarding their efforts toward criminal justice reform. And then after we've heard from all 4 of our panelists, we'll have some of a dialogue between the panel, among the panelists. And time permitting, we will then turn it over to comments and questions from the audience. So please join me in welcoming our panelists and Governor Ehrlich.
Thank you. Thanks. Dan, Carl, thank you so much, both of you, for hosting this. I'm going to be brief because we do want to get some interaction going. Carl's given me about 10 minutes, and I thought I would spend just a couple minutes introducing some folks. I first want to thank everyone seated to my left. Bobby, you are one of the good ones, man. Thank you so much. And we became friends in Congress, and he's a busy guy. And he's a terrific leader in the House of Representatives, and he doesn't need to be here today, but you are, and I really appreciate it. Thanks, Bobby. I call her the Queen. She is the Queen. She is certainly the foremost expert with regard to clemency policy in this country, Margie Love. She was writing nice things about me, and I didn't even know her, which in politics is a wonderful thing, particularly since I was a Republican, too. Jeez. And she has been just a tireless leader with regard to criminal justice reform in this country. We've gotten to know each other the last couple of years, which has really been neat, I think, hopefully for you as well, Margie, certainly on my behalf. And the Attorney General, you are the best, and we've known each other for an awful long time. Your presence here today means a lot to all of us. And thank you for your leadership. Thank you for your life, in your public life, and I'm looking forward to your remarks today as well. There's also a couple folks in the audience here that I want to introduce, and Brady Walker and J.P. Schultes are both of you guys. Stand up. All right. You don't have to applaud. You don't have to applaud. I don't want to spoil them, but both have worked for me for years. Brady's been really instrumental in an announcement I'm going to make in a few minutes. JP was working at a bagel shop out of college when I rescued him to work on my first congressional campaign. Took him to Capitol Hill, graduate of Catholic University Law School, and was one of my lawyers assigned to this project, this clemency project, during my tenure as governor. My chief of staff, Steve Kraszewski's here. We have Greg Massoni, my press secretary. You'll hear more about some of these characters later, but I really do appreciate everybody coming out today. And as I said, I'll be brief. I've developed this sort of stump speech with regard to what we did in Maryland. You all know the numbers, you know the statistics, you know the state of criminal justice in this country, you know the benign neglect most executives, the president or governors have with regard to commutations and pardons. And so when Margie started saying nice things about me as governor, I was surprised, and since I've left office, I've really been surprised at all the attention brought to me, because I had always thought it was simply part of the job. It's what executives do. And for a couple hundred years in this country, it's what executives did, presidents and governors alike. And so all the attention is nice, but it was kind of strange. I'm not going to get into the statistics that all of you are very familiar with. Needless to say, there's an awful lot of people incarcerated in this country today who should not be incarcerated, and they are. And people have to care as a result, as a function of a lot of things, and not just morality, just fiscal sense as well. As we're talking about trillions of dollars, Bobby, and sequesters and all this stuff going on in Capitol Hill. With regard to the Maryland experience, many of you know my predecessor infamously coined the phrase, life is life. And Governor Glendening was a very progressive Democrat with regard to just about every other issue but this issue. And in that respect, followed a tradition in Maryland where executives were generally not interested in clemency policy, and certainly not attacking it as we did. So we came into office, and I said, we're going to do this, and we're going to make it a priority. And of course, in politics, as in business, as in academia, everything can't be a priority. If it is, nothing's a priority. And this was made a priority. In JP's office, fully 1/2 of my assets, 2.5 lawyers out of 5, were dedicated to this project for the 4 years that we were in power in Annapolis. We normalized the process. We made it a regular process. And as all of you know, there's always bad press when an executive, particularly leaving office, issues a lot of pardons all at once, and the press is surprised, and the press never likes to be surprised, and politicians typically pay a price when the press is surprised. And so we began to normalize this process with regard to monthly meetings. Greg Missoni will tell you, in Maryland, as a function of statute, we had to not just announce, but we had to place my decisions in the newspapers. And so as a result, we were successful in taking the temperature down with regard to this issue in that sense, because it was just Ehrlich doing this thing he does. We communicated at a regular basis, and one thing I did find, that once in a while you found a truly innocent person. Exculpatory evidence comes to light years later, and the governor pardons that person. In Maryland, the Board of Public Works, this 3-person panel, decides what compensation that person should get, that person who was jailed wrongfully for years in some cases. One case is over 30 years. And so your decision as governor, or your job as governor, is to literally go in front of the cameras and speak on behalf of 6 million people and say, sorry, here's a check, here's a pardon, and we'll try to do better next time. And that was certainly one of the more humbling aspects of the governorship. As I said, we really took serious investigations, and Bobby, no surprise to you, when JP would call a prosecutor or a judge or a public defender or a witness with regard to a case 22 years cold, it was not necessarily a welcome phone call. The governor's interested in reopening this case. What? He is. Why? And that's not just Greg Missoni, the press secretary, saying why. A lot of people were saying why. But if the essential job description of governor, of president, of congressman, of public official, attorney general, is doing justice, that was my answer. Doing justice, period. And if it made someone uncomfortable, if it made someone revisit a bad result that really impacted a life or lives, so be it. And those phone calls were made, and sometimes we paid the price for it. One of the interesting things about our process was the friendships will be tested. You know, my friends, obviously, my lawyer friends, thought it was going to be a grand parade because Bobby's giving pardons. So usually my friends would find the worst clients they could find and call JP and say, hey, tell Bobby this is important. Man, my guy's paying me big money. And I would say, well, Jay, it's someone we know, so take another look at the case. And JP would come back to me and say, the guy's still a dirtbag. And we would not give that relief. And the Attorney General's laughing here because I'm sure he got some of those phone calls while in office as well. Inappropriate contact will occur. People who should not be calling you about pardons will call you. Judges will call you. And you have to learn to not take those phone calls. And very fortunately for me, my lawyer, my lead lawyer, was a former U.S. attorney named Jervy Finney, familiar to many of you in this room, who protected me, who really did protect me. And for that, I'm always grateful. Your political courage quotient will be tested. This is a very strange issue, and I'm going to close in a second, but the left, for some reason, doesn't much care about this issue, and the right has never really cared about it, so you're not going to get a whole lot of credit from either side. Again, some people would ask, well, why are you doing it? Same answer as I gave you before. We did not keep score. I did not keep statistics with regard to race, ethnicity, sex, income, whatever line we want to draw. We just took the cases as we found them. And again, as a function of merits and as a function of justice. Now, J.C. Boggs is here. Josh Toll is here. Josh, stand up. J.C.'s here from King and Spalding. And last week, Kara, I was at the law school, and Kara yelled at me because I was supposed to make this big announcement, and I didn't in my prepared remarks. So today I'm going to make up by re-announcing an initiative that has been in the papers and was reported by the Washington Post, and which was my interest in establishing a partnership at a local law school with regard to a clemency clinic. A clemency clinic which would have constituent elements with regard to advocacy and training for new governors, and a clinical component as well. And once that article appeared in the Washington Post, within 24 hours, I had calls from 5 deans from area law schools. I announced last Friday that we have chosen Catholic to host our partnership, and I like making her happy. And not you, her. Yeah, no. And Josh, you want to make an announcement as far as the first check here?
Yes, King and Spalding is very pleased to support Governor Ehrlich's project by donating an initial donation of $5,000 with another $5,000 to come next year.
Thank you very much. We appreciate that. Yeah. So that's all. I look forward to our discussion. I really, truly appreciate folks coming out here today. There are a lot of people in jail who really shouldn't be behind bars. They're taking up space, they're wasting their lives, and they're costing taxpayers a lot of money. And hopefully this initiative, events like today, can move the ball forward in this country. Thank you all very much, and Godspeed.
Thank you, Governor. It's exciting news. Glad that it's public. And General Meese, we'll hear from you next. Thank you.
Thank you. It's a pleasure to be here with the people that are here on this panel, and with whom I've had a chance to work in very different capacities. But I'd like to talk a little bit about a couple of things. First, some experience in the clemency field. Secondly, a little bit about clemency as part of the criminal justice system. Then a third thing, which I call getting people eligible for clemency. And then discuss a little bit about where I think we ought to be going. As most of you know, clemency, historically, is one of the oldest and most universal prerogatives of a sovereign. And it goes back, if you read your history, all the way back to kings and monarchs of various sorts, even biblical. And you can see sometimes it's been used to increase fairness, sometimes it's been used in other ways, or denied as an aspect of a monarch's actions. But it has always been one of the things that's been a very important part of anyone who has responsibility for ruling a country, a state, or some other jurisdiction. In 1967, out of the blue, I received a call asking if I would like to come up and meet the new governor-elect. The governor-elect was Ronald Reagan, and after spending a half hour with him, I was not prepared to do anything or make any change. I enjoyed what I was doing. I was a deputy district attorney in a very good district attorney's office in Alameda County. My boss had been one of the founders with the district attorney of New York, founders of the National District Attorneys Association, and I enjoyed very much the work I was doing. But after a half hour with Ronald Reagan, I was convinced that my plans were about to change. I remember driving home 75 miles from Sacramento to Oakland and trying to figure out how I was going to explain to my wife we were moving. But the interesting thing was, as it relates to clemency, was when I was shown the clemency book in which everything had to be inscribed, it was a book that weighed 20 pounds. It was one of these thick books. It was about 4 or 5 inches thick, and everything was written there. I think it went all the way back to 1850 when they started the state, probably previous volumes, but everything was done that way. And that was significant, I think, because it illustrated the way in which clemency had been regarded. And that was the pen and writing rather than using such things as modern implements such as typewriters. And that was one of the first things we changed and used 8.5 by 11 pieces of papers in ring binders, which were a lot easier for somebody else to write in there and also easier for people to read. In any event, there were a couple things that particularly bothered me about clemency when I took over the job. The position was Legal Affairs Secretary, and it had a number of responsibilities, including the liaison with law enforcement, the judiciary, and the legal profession. But one of the very important duties, beside extradition, which is kind of traditional for these kinds of positions, but also was executive clemency. And there were two things that bothered me particularly. One is that the pardons were given only on Christmas, as though it was a Christmas gift from the governor rather than something that had been earned by the individual. And the second thing was that they always published the names of all the people who were getting pardons in the newspapers throughout the state. Now, if you were a person who had done your time, had reconstructed your life, had perhaps married someone who, while knew about your past, wasn't particularly interested in it, and certainly the people you worked with or the people you worked for were not, in many cases, were not cognizant of it particularly. And then to have it splattered all over the newspapers that you had just been granted clemency by the governor and in pardon for this offense you committed 15 years before or 10 years before, whatever it might be, this was hardly the kind of thing that enhanced that Christmas present. So those were two things we changed, and that is the governor considered pardons on a regular basis, and at least 4 to 6 times a year would sign the pardons and so on and go through the process. The second thing was that we did not release them to the press, and although we thought that the press would be highly upset because, as was mentioned earlier here, the press doesn't like to be surprised. Nevertheless, when we explained the reason for this, the press went along with it, and we were able to change things. One other thing that I want to mention about California, and that is it is not totally left to chance whether a person receives clemency or not. We have a process in California even though I've been here 30 years, I still think of myself as a Californian, and that was a certificate of rehabilitation, that a person could initiate their own process by seeking a certificate of rehabilitation and going through certain processes in which your rap sheets are checked to make sure there are no recent offenses since you've gotten out of prison and so on. And as a result of that, that goes before a Superior Court judge, and that judge then can grant a certificate of rehabilitation, which then goes directly to the governor, and much of the work that would otherwise have to be done by investigators at the state level, which often slows things down or makes it much more difficult, is being done in the 58 counties. And when that certificate comes into the governor invariably grants the pardon. And it's an ability then to self-execute. In terms of clemency as a part of the criminal justice process, you know, when I was teaching criminal law before I came to Washington, one of the things that most of the books and the charts they showed you of the criminal justice process starts with the commission of a crime, then goes to an investigation and an arrest and a prosecution and a trial, and if there's a conviction, then incarceration, and it stops there. And there's no real attention given to their at least 4 steps that follows that. One, of course, is what happens while the person is in prison. A second is a decision as to when that person is released from incarceration. The third is what are the post-incarceration conditions and what is the process there. And finally, clemency. And those are pretty much neglected in any class on criminal law or criminal procedure or in the minds of most members of the public. And I think one of the things that is extremely important and worthy of a lot of attention, along with the clemency clinic and things like that, is what happens to get enable a person to be deserving of clemency, and that is what happens while they're in prison. I would bet that, I think, Governor, you probably in your time visited prisons. I visited a lot of them, also was able to get out. But one of the things that happens, I have always said, is that very little is paid to what happens when a person is in prison. We call them correctional institutions, but they're real questions about what they correct. In California, it's now the Department of Corrections and Rehabilitation. And most of the things that happen while you're in prison are the opposite of things that are rehabilitating. Humane treatment, respect for as an individual, all those kinds of things are usually not present. And in terms of if you were really trying to get a person ready for clemency or get a person ready to go back into constructive citizenship, then it seems to me that there are things that should be done in order for that to happen. And among them, of course, are treatment. We have far too little treatment in correctional institutions for the 2 things that I'd say well over 90% of the people are involved with. One is drugs, and the other is alcohol, and sometimes both. And unless that treatment is successful, it's going to be very unlikely that person is going to be in a situation where clemency is appropriate in the future. And I'm distinguishing clemency now for those convicted as opposed to the other situations that were mentioned, such as pardons on the basis of innocence or something along that line. But I'm talking about the person who goes through the process. The other things that are needed in prisons are, one, work programs, and secondly, the programs of education. I would say that at least one or more of those 4 things, drugs, alcohol, lack of education, and lack of work skills or work habits, are probably the situation of a high percentage, I'd say probably 80 to 90% of those people who are in prison. And so I think one of the things that has to go along with the other things we've been talking about is improving prisons. As I said, when you visit a prison, you realize that the food's better, the laundry's better, perhaps the facilities are better than they were 100 years ago, but what goes on in prison is not awfully distinguishable from what went on at the beginning of the 20th century, let alone at the beginning of the 21st. And I think, if you look at the people who are running prisons, and this is not true of all, some prisons are a lot better than others, but the correctional officer's main objective is to get through the week without getting stabbed or otherwise injured. The unit supervisor, his objective or her objective is to get through the month without having a major disturbance in their cell block. The person who is the captain, he wants to get through the quarter without having a major riot in the yard. And the superintendent wants to get through the year without going over his budget. None of them, or very few of them, are thinking about how do we take the people that are committed to our care by the state and turn them out at least no worse off, and in some cases we hope better off than they were when they came in after their conviction of a crime. And so I think that in order to have people ready for clemency or deserving of clemency, and in other words, ceasing to be involved in the criminal activity that brought them into the prison in the first place, is to improve the conditions in the prison. And then, of course, in terms of the release decision, we've talked about that today, and that is the whole idea of making sure that the right people are in prison for the right period of time. There's no doubt in my mind that one of the reasons why crime has gone down is that a number of serious habitual offenders have been put into prison, and they've been there for a longer period of time than they had been in the past. And that, as a result of that, that has been a major factor in reducing crime. On the other hand, as has been pointed out, there are a lot of people who don't need to be there perhaps at all, and certainly not for as long a period as many of them are, for artificial reasons, rather than for real public safety reasons. And so I think these are areas in which a great deal of attention can be paid. And the last thing I want to mention, because of Congressman Scott being here, and that is we have too many crimes in this country. In order to convince the legislature or the Congress that something is important, and to convince the public or to convince their constituencies that something is really important, it's commonplace now, particularly in Congress, to add a criminal penalty to conduct that nobody would think of as being criminal. You look at all these regulations that are passed by regulatory agencies under a statute that says violation of these regulations shall be punishable by such time in jail or prison or such a fine or both. Well, many of these things, as we've seen by the anecdotes that appear rather frequently in the newspaper, and something that Congressman Scott and Heritage, where I work at our legal center, are trying to do, and that is to say, let's reserve the most serious imposition of governmental power, criminal sanctions, on only those things that are really important and are really deserve and have a moral aspect to them, rather than simply as a convenience for social engineering. Well, those are a few ideas that I'd like to throw into the mix, and appreciate the chance to be here with you.
Thank you, General Meese. I think those were more than a few ideas that you threw out there, but we appreciate your thoughts and expertise. And now we'll turn to Congressman Scott for his thoughts.
Good evening. And thank you, Professor Drynan, for the opportunity to be here. I think I understand that your grandfather's cousin was dean of the Boston College Law School when I was there. And so I appreciate him letting me into the law school. Dean, it's good to see you. And good to see Ms. Love, who's got a strong reputation in this area. Ed Meese, who he just indicated would work together on the issue of over-federalization. And of course, a friend, Bob Ehrlich, who I knew as a member of the House before he was governor. He was one of the thoughtful members of Congress. I mean, that is not a huge caucus, I can tell you that. I want to introduce Bobby Vassar, who's the chief counsel on the crime subcommittee and probably one of the most knowledgeable people in criminal justice. He was formerly chair of the Virginia Parole Board in his former life, and is my legislative director, and then with the crime subcommittee. And Charlie Sullivan, who with CURE, working to help prisoners get back on track. Charlie, it's good to see you. I'd like to thank Professor Drynan for inviting me and the opportunity to be here, particularly in light of the fact that one of my staffers, David Daly, is one of her students. He is at Catholic Law School at night, working hard during the day. So he's obviously learning a great deal and bringing it back to the office. And I want to thank Governor Ehrlich, who's one of the, mentioned the area of clemency and pardons. There's one of the uses of this is that because of the war on drugs, a lot of these drug sentences have people in jail for draconian punishments for situations that really don't need anywhere close to that. But the mandatory minimums they're subject to put them in jail for decades, and clemency is obviously appropriate for that. But sometimes the process doesn't work so hot. John Conyers, a ranking member of the full Judiciary Committee, and I wrote the president requesting the Attorney General to investigate the case of Clarence Aarons. Apparently, the evidence is that he didn't get a fair hearing. Hopefully, the president will give him a new hearing with the appropriate evidence before him so that he can get the appropriate consideration. Now, one of the things that we also asked the president to do is set up a pardon situation for the appropriate resentencing through the clemency process, because I'm not sure there's a judicial process that's available at this time for those who should have been affected by the Fair Sentencing Act. Most people knew that the crack powder disparity, 100 to 1, 5 grams of crack, 5 years mandatory minimum, 500 grams of powder, 5 years mandatory minimum, 100 to 1 ratio. We reduced that to 18 to 1. Should have been 1 to 1, should have eliminated the mandatory minimums. But 18 to 1 at least gets you into an area where you're dealing and where you're talking about thousands of dollars worth rather than about a weekend's worth of drugs. We need a situation where they can be resentenced pursuant to the new law. A lot of people, for minor amounts of crack, personal use amounts, are in for 5 years and sometimes many more. Now, many states have come to grips with the criminal justice need for criminal justice reform. And when we talk about criminal justice reform, we have to recognize that they come to grips with it not because they've studied the issue and have seen the light for a more intelligent way of doing things. It's because their budgets have gone out of control. California, for example, in 1980, spent 10% of its budget, state budget, on higher education, and prisons, 3% of the budget on prisons. 10% on higher ed, about a third of that on prisons. Now, higher ed, 6.6%, prisons, 11%, from about a third to now twice as much. And that cost has caused people to stop and think, well, maybe we can do things differently. Now, I've worked in the criminal justice system as a legislator. Kara mentioned that I've been in Congress for over 20 years. I was a state legislator before that. And so for 35 years, I've been legislating in the crime area, and I've noticed that we really have a choice with crime policy. We can reduce crime, or we can play politics. Unfortunately, you can't do both, and what we've been doing is basically playing politics, codifying a bunch of simple-minded, tough-on-crime slogans like 3 strikes and you're out, life without parole, truth in sentencing, mandatory minimum sentences, and if you can get it to rhyme, it's even better. If you do the adult crime, you do the adult time. And my favorite is one candidate for governor in Virginia actually ran on this slogan: no cable TV in the prisons. You can just see the cable guy showing up, disconnecting the cable, and everybody saying, oh, now we're safe, now we're safe. Crime is going down. And some of them don't really do much about reducing crime. Some are actually counterproductive. If you do the adult crime, you do the adult time, that means you're trying more juveniles as adults. Most juveniles with the heinous crimes already tried as adults, so if you try to codify that slogan, that means those who would not be now tried as adults, tried as adults. And just think of going into one system or another, going to the juvenile system where the judge can order education, psychological services, even family services. The adult court judge can either lock them up with adult criminals, drug dealers, murderers, and rapists, or let them walk out of court, one or the other. And guess a few years later who is more likely to be back in the criminal justice system? Trying more juveniles as adults, every study has shown that it increases the crime rate, not decreases, but it's a popular sounding slogan and everybody wants to do it. Mandatory minimum sentences have been studied. They've been studied and shown that they discriminate against minorities, they waste the taxpayers' money, they disrupt the rational sentencing system, and often violate common sense. You see this in the drug laws, where you are charged in a conspiracy with the weight of the entire conspiracy without any regard to your role, without any regard to the seriousness of the crime. They just look up on the matrix, this much weight, that much time. They've also shown in some cases where they can be bizarre. Marissa Alexander in Florida had an abusive husband who was coming to her. She shot a firearm in the air to ward him off. Discharging a firearm, in that case, 20-year mandatory minimum sentence, which is so bizarre that if she had just lowered the weapon, shot and killed him, aggravated manslaughter, 15 years maximum. She got 20 years minimum, and shows what can happen. If you're going to do something about mandatory minimums to get them off the books, the first thing you have to do, of course, is stop passing new ones. About every crime bill that flows through has some new mandatory minimums in it. Now, all these codification of slogans and sound bites has gotten us to the point where we're now locking up a higher portion of our population than any country on earth. And this, did you get these? Okay. We lock up a higher portion of our population than any country on earth by far. Okay. The first chart shows the green bars per 100,000, how many people are in jail today. Most countries is 50 to 200. Russia is a little over 500. United States, the red bar, number one in the world, 700 and some per 100,000. African American, average rate 2,200. 10 states lock up blacks at the rate of almost 4,000 per 100,000. Now, those numbers are particularly egregious because the Pew Center has done research on this and concluded that any rate over 350 per 100,000, you're getting diminishing returns. Anything over 500 is actually counterproductive. You're messing up so many families. You got so many ex-cons wandering around the community that no businesses want to move in, no businesses, no jobs, more crime. Actually counterproductive, anything over 500 per 100,000. We're starting off early. Chart number 2 shows the youth incarceration, where we're just off the chart. But these things don't come for free. We need to show the cost of this, and the last 2 charts on the back show that if you reduce the African American incarceration rate from 2,200 down to 500 per 100,000, chart number 5, you'd have 1,700 fewer people incarcerated, $50 million a year wasted, counterproductive incarceration. And if you divide that up among 1/3 of the children that are at risk, you could be spending $5,000 per child every year on what those communities are wasting on counterproductive incarceration. Now, 10 states, that bottom line is $10,000 per child per year wasted codifying slogans and sound bites. Now, we can do better than this. We obviously have to enforce the laws that are on the books if people are committing crimes, but one reform that's necessary is to refocus our efforts on prevention and early intervention, getting children out of what the Children's Defense Fund calls the cradle-to-prison pipeline and put them into a cradle-to-college and career pipeline. Now, you can just look at the money. We have the money to do that, and if we spent the money like that, we could significantly reduce the incidence of crime. And the evidence is clear that if you have a research-based comprehensive plan that starts early and is comprehensive from very early I mean teen pregnancy prevention, so fewer babies are born into dysfunctional families. Prenatal care can reduce learning disabilities and mental retardation. Nurse visits can reduce child abuse, which is highly correlated with future crime. Early childhood education, so they're on the way to getting a decent education. Make sure they read by the 3rd grade, because if they can't read what teachers tell us is up to the 3rd grade, you learn to read. After the 3rd grade, you read to learn. If you can't read by the 3rd grade, you're not learning after the 3rd grade, and you're on the way to dropping out. And chart number 3 shows what happens when you drop out. The bottom line on that chart is that for African American males 25 to 30, high school dropouts, they're more likely to be in jail than working if they've dropped out of school. If you don't have at least a high school education today with a high-tech information-based economy, you're not going to get a job. And so if we have a continuum of services from very early to get them into college or the workforce, because once they're on the job or into college, crime rate plummets. We can do that with the money that we're wasting today. That's why I introduced the Youth Promise Act, which takes advantage of that. It requires a community to come together, first decide they're going to be serious about crime, and do research and study to construct a plan based on what's going on in the community, how much are you wasting on prisons and other social pathology that can be cured with good prevention programs. Particularly teen pregnancy will also go down with a good crime prevention program. And look at how much money you're wasting today. Come up with an evidenced, comprehensive plan to put it together. Now, as I indicated, a community of 100,000 on average may be wasting as much as $50 million a year. Put that money in the middle of the table as you discuss what your options are, because if you're going to cut the crime rate in half, which is not hard in a high crime rate area, you don't want to limit your thinking to programs that cost $15,000 if you're going to be saving millions. The Youth Promise Act will fund the program for the first year. After that, the people that are around the table helping to put the program together will figure out who's going to save some money. Corrections is going to save some money. Medicaid is going to save some money. Other areas are going to save some money. Get them to commit to kick some of that money back in. We know you're going to save money. Pennsylvania funded about 100 programs for a cost of about $60 million a few years ago. They went back a couple of years later. It spent 60. They calculated that they saved about $300 million. So you don't even have to get them to kick in all the savings, just get them to kick back some, and you can have the programs funded into the future. Boston did one of these. They reduced the juvenile murder rate from 13 a year to 0 for 3 consecutive years. A program in Richmond, Virginia, reduced an area 19 murders. A couple of years later, 2. And if you just think at the number of gunshot wounds that survived and those that were killed, the money that the Medical College of Virginia trauma unit saved, didn't have to treat. We know that that savings there was probably more just in hospital costs than the $2.5 million that they spent. We know these programs work. Youth Promise Act has strong support in the House, but like I said, there's a choice. The anti-gang bill in the Senate, let me just give you one provision in it. If you're identified as a gang member some kind of way and commit a violent crime that is not serious, violent crime not serious. Now what's that? What, a schoolhouse brawl or something? Not serious. You can get, under that bill, up to 20 years to serve, 20 years. Now, how many people think a bill with that kind of provision could pass the United States Senate? Well, it did. Anybody remember what the vote was? No, you don't remember what the vote was because they didn't take a vote. They passed it by unanimous consent. It came to the subcommittee. That time the Democrats were in control of the House. I was chair of the crime subcommittee. And the reason you don't remember the bill is that's the last anybody heard of it when it came to my subcommittee. But we have to make that choice, and if we make the right choice, we can significantly reduce crime and save a lot more money in the process. The Attorney General mentioned we know those programs save a lot more money than they save. 2/3 of the prisoners are going back today. We can do better than that. Let me just mention the fact that the Attorney General mentioned over-federalization. Some of that is dealt with the Lopez decision, where the Supreme Court says you just can't federalize everything. You have to have some constitutional basis for it. And so we're trying to reduce the federal crimes. There's no reason for a federal carjacking statute. If you're a victim of carjacking, you're not going to call the FBI. You're going to call the local police. So we need to make sure that, and some of the regulations that don't even have a mens rea attachment to it. People are committing crimes and going to jail for things they didn't even know were crimes and were innocently just caught up in some mess. And we need to make sure that you have the mens rea as part of as an element of the crime. We know that we can do a better job than we're doing. We know a lot of these smart on crime initiatives will save more money than they cost. And it's just a matter of us doing what we know is the right thing to do. Thank you very much.
Thank you, Congressman. And last but not least, we'll hear from Ms. Love.
It's such a pleasure to be on this panel. It's such a pleasure to talk about this subject, and I have heard Governor Ehrlich speak about it frequently, but to hear General Meese speak about it was a particular treat. And it's wonderful for me to hear Governor Ehrlich talk about clemency and the use of the pardon power as part of the job, a routine part of the job. Yeah, that is true. It is a routine part of the job, and it's not only a routine part for the particular individuals whose cases are brought before a governor or a president. It's also a routine part of the way that a chief executive speaks to his constituency, the way he speaks or she to other branches of government, to the prosecutors, and to the public. And I think it's a tremendous opportunity. If Congressman Scott were president, you see, you could give that speech. And you could give it in a way that so illustrated through your pardon power the way those reforms would work. It's kind of interesting. I wrote an article once where I said that the only two chief executives that took their pardon power seriously were Robert Ehrlich of Maryland and Josiah Bartlett of the West Wing. And in truth, there was a wonderful episode of the West Wing, which I was actually privileged to see them filming. It was really quite fun, in which the president, in his State of the Union address, announced to Congress that mandatory minimum drug sentences that resulted in draconian, sometimes lifetime sentences were going to be repealed on his watch, and that he had, that day, he had commuted the sentences of 15 low-level, nonviolent drug offenders. This was my fantasy, right? And it really happened, and you can go and find that episode of The West Wing in the archives. Julie Stewart was in that episode, actually. It's funny. The head of Families Against Mandatory Minimums, except rather than being a very attractive white woman, she was a large black man. and I think maybe they might have had Bobby in mind for that model. In any event, it's a wonderful thing to hear pardon and the pardon power spoken about as part of the job. And I think that when a chief executive stops regarding it as a part of the job, even if it's only as much to point the legal system in a way that is more functional. Because after all, pardon really is not supposed to make up for flaws in the legal system. I think you did a wonderful job, Congressman, in pointing out some of these flaws. Yes, the president could commute some sentences, but he cannot commute 5,000 sentences or more, and that's the number of people that we estimate are would have been affected by the Fair Sentencing Act if it had been made retroactive. The tremendous burden imposed by the collateral consequences of conviction. This is people who are long out of prison, sometimes many years, who are still suffering from laws that impose restrictions, limitations, burdens. It's really interesting to hear General Meese mention the California pardon system because, frankly, for about 20 years, there was no pardoning going on in California at all. Governor Reagan pardoned, I think, 575 people. I have that figure in my head somewhere. I actually wrote a book about this, so I have these little numbers. Governor Brown, in his first tenure, pardoned a number of people. Governor Deukmejian did, but then it all stopped. And 20 years, there were almost no pardons at all. There were a few rather strange end-of-term pardons from the most recent governor before Governor Brown. But Governor Brown, I am thrilled to say, has brought back pardoning to California. He's pardoned 144 people, and all of the cases came through that court process. It's very functional. They actually have a little additional thing now. They take it to the Prisoner Review Board after the certificate coming from the courts, it goes to the parole board, and they kind of have a centralized system. It's a little top-heavy. I don't know why they need to put that stage in there, but it's a very functional system. And law reform organizations that are now trying to figure out, how do we deal with these long sentences? How do we deal with the collateral consequences problem, the secret sentence, the invisible punishment? We should use the courts more frequently. I am very interested in the way the process for administering the pardon power works, and how it can facilitate and encourage an executive to do more pardons, how it can protect him or her. Because that was my job in the Justice Department, it was a little bit of a frustrating job, because when I was pardon attorney in the early 1990s, early and mid 1990s, the idea of pardoning was really not regarded with much enthusiasm. I'm afraid that's still the case. The system for administering the president's pardon power has become quite broken. States are doing so much better. There are a lot of different, very interesting ways that states administer the pardon power. But frankly, it appears to me, having done a little study of them, that the federal pardon process is probably the most dysfunctional, primitive, and unhelpful of any in this country. I believe that in time that process will change. It has badly disserved the last two presidents. President Clinton, everyone knows those end of term pardons. He was actually trying to, his goal was to grant as many as President Reagan had granted, but he thought he could do them all on the last day. President Reagan was a very responsible pardoner and did over 400 pardons. The current president has done 22. President Obama's pardon rate, I try to say without appearing judgmental, is the lowest in our history. Our history, except for the two presidents who died within about a week and a half or two of taking office. Even George Washington and John Adams pardoned more than this president. Now, I hope that will change, and I'm working hard to help it to change. There are a lot of wonderful things about pardoning, and Governor Ehrlich can tell you. General Meese can probably tell you too, because he was there with Governor Reagan when he was doing it in California. It should be one of the happiest duties of the executive. It should be easy, but it has become unhappy and very difficult, at least in the federal system. So I'm hoping that with this wonderful new program at Catholic University, we can start getting some discussion going. There are lots of states that have good stories to tell. There are probably 15 or 17 states that have a functioning pardon program. Lots of different ways to do it, whether it's independent boards or what I call gatekeeper boards, or boards that the governor sits on, or something like the California system where it goes through the courts first. There are lots of different ways to do it. But it's a tremendous opportunity to see how the clemency system works, and how it could work, and how it could encourage changes in the legal system that we desperately need. So thank you very much.
Thank you so much to all four of you. That was really, really educational, and I'm someone who researches in this field, so that says a lot about the thoughts and ideas you've shared. I had envisioned that we would have some dialogue among the four of you, but given that you've already sort of referenced each other's thoughts, and given the time and the commitments of our panelists later this evening, I think it makes sense at this point to open the floor to comments and questions from the audience. And if you don't have questions and comments, I have lots. But I would like to give other folks an opportunity at first. All right, well, maybe while you're thinking about comments and questions, I will start with one for, I think, everyone on the panel, which is that Governor Ehrlich, you have mentioned many times when I've heard you talk on this issue that there's no upside for politicians doing this, right? And Congressman Scott, you said something similar tonight, that politicians have a choice; they can reduce crime or play politics. So I guess my question, and I think all of you on the panel can speak to this, is how do you convince other politicians to get on board if in fact there is no upside?
That's one of the charter items in our partnership, sir, isn't it? That hopefully, and you have a governor's election, gubernatorial election coming up in Virginia, hopefully we'll be able to attract at least chiefs of staff, newly elected chiefs of staff, to Catholic, whether it's a 1 hour or 1 day or multi-day exercise, to think about this. Probably non-lawyer governors, many don't even think about this stuff. With regard to lawyer governors, I think there's no excuse. I think there's no excuse generally. So I think just simply having resources and getting someone to think about it counts. I'll also add this, and Bobby and I were just talking quietly here. The Willie Hortonization, the new verb to American politics that occurred over many, many years, to Willie Horton somebody, this clearly is, we're all referring to it. It is what it is, and this has to be obviously a very careful process. But my observation is, someone's been in a state legislature and in Congress and is governor and runs around the country giving speeches and all that, is there's less downside with regard to an active process today maybe than ever before, Congressman, because more families have been impacted by the criminal justice system than ever before. And the lines we like to draw, class, race, and all that, I think are less relevant today. When you can go to a conservative audience and say, who's impacted by the criminal, whose cousin, who's had some experience with the criminal justice system, and an awful lot of hands are going to go up. So I do think there's less. It doesn't mean this is a very serious process. As for the upside and all the wonderful things you can do, it's serious, and there are lots of people who belong in jail for a long time, and some forever. So, but bringing a sense of balance and dignity and justice to this is what we're really talking about.
One of the problems is it's in this kind of 30-second commercial world we live in, it's hard to compete with a good slogan, but the last thing you want to do is be defensive. I've always told people, if you're going to take an intelligent position on crime, you shouldn't apologize for it. You really need to go on the offensive. And if you're in a debate and your opponent points at you and says, Bobby Scott's soft on crime, I need to point back and say, let's have a discussion on crime, because my opponent will vote for any simple-minded slogan or soundbite his pollster tells him will help him get elected, even if it wastes money and will increase the crime rate, and I can prove it. The next debate you have, my opponent will point to me and say, Bobby Scott's going to raise your taxes. You can't apologize for it. You have to go on the offensive. Our position makes sense, reduces crime, saves money, and theirs makes no sense. It just rhymes and is silly. But one thing you have to do is stick to evidence-based. And the Attorney General had a report on problems with children exposed to violence. And in that report, almost every page, they said evidence-based, as opposed to slogan-based, emotion-based, sounds like a good idea-based, evidence-based. And if you stick to evidence-based, you've got a sound basis for your discussion. And one thing if people don't care anything about the policy, they do care about the money. They can't afford the simple-minded system. We're spending so much money. As I indicated, California is spending now almost twice as much on prisons as higher education, when it was about 1/3 of the higher education budget went to prisons, and that's twice as much. At some point, you just can't afford to be simple-minded. You have to get serious.
I'll add to that a comment that this is an illustration of not so much the prison problem, but the collateral consequences problem. The current governor of Ohio, John Kasich, who's quite a conservative fellow, has been incredibly progressive on criminal justice issues. One of the first things he did was to say we are going to stop sending people to prison for fractional periods of a year. It's stupid. We do not need to send people to prison for 30 days. It's inefficient, and it does nobody any good. The other thing that he did, though, and he's a very practical businessman. I don't know him. I wish I could meet him because I really admire what he's done. He talked about collateral consequences, and I heard a speech that he gave where he said, look, I'm a businessman. I have 5,000 trucks out in the yard somewhere, some yard, that need drivers. I have no drivers for those trucks because in Ohio, someone with a felony conviction cannot get a commercial driver's license. That's a collateral sanction. Now, one of the things that Governor Kasich did, he has not pardoned a lot of people, although I have to say his capital record has been quite interesting and admirable. His record in capital cases. He's commuted half the death penalty cases that have come before him. But what he did is he encouraged the legislature to enact a certificate of qualification for employment, where someone who has been convicted in the past can go to court, again, it's a court-based system, and get a certificate. The one thing that I would change about the California system, General, is that the certificate independently doesn't have much legal effect. Now, the Ohio certificate has a lot of legal effect. And so you can go to court and you can get a sanction removed. You can be declared in Illinois fully rehabilitated by the court. This is very helpful for people. It's a good substitute for a pardon. We don't have anything like it in the federal system, nothing. So states are figuring this out. They are developing different ways to compensate for the deficiencies of the legal system that don't always require the exercise of clemency.
I would say that this should be a responsibility of the legislature. You mentioned that non-lawyer governors probably don't think much about this, but certainly lawyers should be. And actually, most lawyers have very little to do with criminal matters. But it seems to me that among the other things that bar associations ought to be looking at is this particular issue. First of all, because they'll have more credibility with the public generally, and can, in a sense, take the pressure off the members of the legislative body if they have the bar, if the bar has indicated. And also, I think that even victim organizations, surprisingly, victims in many cases, rather than being vengeful, are really looking for a better solution to what happens after a crime. And so I think there are a lot of resources that haven't been tapped, and just panels like this, an educational program on the subject, I think could go a long ways towards changing the climate and making it a lot easier for legislators who are willing, like a congressman here, to stand up for these issues.
Great. Thank you. I had planned to ask a second question, but I'm realizing that in light of the time, I probably won't be able to touch on the issue of the experience of prison, which General Meese, I'm really glad that you raised that point, because you're right, we don't teach that in criminal law. And announced tonight that I'm going to start taking my criminal law students on field trips to prisons, because I think that's an important piece of the puzzle, that that students experience that in some way. So maybe we can continue that conversation on another day. Please join me in thanking this really illustrious panel that we've had tonight.